Hey y'all, welcome back to another episode of The Business of Doing Business. I'm Yasmine Salem Hamden, and today we're tackling a big question that I get all the time as an intellectual property attorney and business advisor. And that is, what is a trademark? If you're building a brand and selling products or services, understanding IP and trademarks in particular is a necessity. Let's dive into what trademarks are, how they differ from copyrights, another form of IP, and why they matter for your business. So let's break it down. A trademark is a distinct source identifier that you use commercially in connection with the sale of goods or services. This could be your company name, a slogan, a logo, or even a hashtag that you use in your marketing materials. It's not just your LLC or corporation name. It's about what your consumers see and recognize as your brand. To help you understand the difference between trademarks and copyrights, let me share one of my favorite metaphors. Picture a box. This box has all sorts of packaging on the outside, labels, designs, logos. As a consumer, when you look at the outside of the box, you don't know exactly what's inside yet, but you already have a pretty good idea about where this box came from because you can see the brand name, the logo, the slogan, the color scheme, and maybe even a distinctive design or logo that sets it apart from all the other boxes out there. These are your trademarks as a business owner. Your trademarks are all of these identifiable labels on the outside of the box. And based on that, you might already have assumptions about the quality, experience, and value that you can expect just from the outside of the box, which is pretty incredible. Now, when you open the box, that's where you find your copyright assets. These are the contents inside the box and the literal content and creative works that your business produces. This includes visual works, audio works, and written works. So while trademark law protects the branding and the source identifiers, copyright law protects the content itself and your rights to the use of it. Now, back to focusing just on trademarks. I want to talk about the different categories of distinctiveness that trademarks fall into. So there are 5 categories of distinctiveness. The first of them and the most generic of them is generic trademarks. Generic trademarks are common terms that everyone needs to use, like using the phrase website shop for web design services or podcast production for podcast related services. The next category is descriptive trademarks. Descriptive trademarks describe a feature of the product or service, like using the phrase compelling copy for a copywriting course. Now, let's take a moment to break this down a little bit further. Generic and descriptive marks are not protectable as trademarks because you cannot claim exclusive rights to use something that other people need to use in order to describe a similar product or service. Here's a good informal test that you can run if you're wondering, okay, is my trademark protectable? Ask yourself, do others who sell a similar product or service need to use that language, that word, or that phrase just to merely describe their product or service? And if the answer is yes, then you might not be able to claim exclusive rights to the use of that trademark. But if the answer is no, then your trademark may fall under one of the other more protectable and distinct categories. So let's get into those, the last 3. So we talked about generic and descriptive, not protectable, more generic, more descriptive, kind of self-explanatory there. And then the last 3, we're going into the more distinct categories here. So the next one is suggestive trademarks. Suggestive trademarks suggest a quality or a feature without directly describing it. So something like this might be Microsoft. They use the word soft, like software, microchip. It's kind of suggestive. Another one that you're probably familiar with is Netflix. So net, internet, flicks. It's another word for movies, Netflix. It's suggestive and it's pretty distinct. So this type of trademark is protectable under trademark law. The next level is arbitrary. Arbitrary trademarks are common words used in an unrelated context. So a very popular one is Apple for computers. Apple is a word that exists in the dictionary. However, it has nothing to do with computers. So it's totally unrelated in the context, making it very distinct. Other computer or technology companies would not need to use the word Apple to describe the product or service that they're selling. And then finally, that brings us to our last and most distinct category, which are fanciful trademarks. Fanciful trademarks are made up words such as Google for a search engine or Sharpie for a permanent marker. Because these types of trademarks are very distinct, they are protectable and you can secure exclusive rights to use them in connection with your specific types of goods and services. Now let's talk about a situation that some of us may find ourselves in, and it's not exactly the most fun situation to be in. plan. What happens if you find someone else using a trademark that's similar to yours? Before you take any action, you want to consider a few important factors. First, ask yourself, do I actually have the exclusive rights to the use of this trademark? It's important to note that even if you don't have a federally registered trademark, you might still have common law rights if you've been using the mark in commerce, meaning commercially. However, these rights can be limited to the geographic area where you've been using the trademark. So if you are selling products or services outside of your state, it is a great idea to explore trademark registration so that you can secure the exclusive rights to the use of it across the country. And if you're active in other countries outside of the US, you can also register in each of those countries. Next, consider whether the trademarks are actually similar. It's not just about the exact match of the words or images, but also how they look, sound, and what they mean to consumers. Also, you need to think about whether the goods or services are similar in nature. Trademarks can coexist if they're used in connection with different types of goods and services, even if the trademarks themselves are identical. Here are a few examples of trademarks that coexist because they're used for different types of products or services. Delta. You might think of Delta as the airline, but there's also Delta faucets. Both companies use the same name, but they operate in completely different industries. One is in air travel and the other is in plumbing products. Because of this distinction, their trademarks can coexist without a likelihood of confusion for consumers. The next one is Apple. Most people know Apple as the tech giant behind the iPhone, but there's also Apple Glass Repair. Since one is in technology and the other is in window and glass repair services, they both can use the same name Apple without causing consumer confusion. And my final example is Dove. Dove is a well-known soap brand, but there's also Dove chocolate. Because they operate in different sectors, both companies can use the same trademark with no likelihood of confusion for consumers. All right, so now let's shift to talking about selecting a trademark and how we can carefully and intentionally select a trademark. When you're selecting the trademark for your business, aim for something suggestive or arbitrary. Avoid generic and descriptive marks because they're just hard to protect and maintain exclusivity of, and you don't want to be one of a million people using a brand name for your company. It's going to make it difficult for people to find you, and it's just not a best business practice. I encourage you to do a trademark clearance search on your own to ensure your chosen trademark isn't already in use or registered. This can help you avoid expensive legal disputes, forced rebranding, being on the receiving end of a trademark infringement lawsuit, just not fun stuff, not the things that you want to be spending your time or money on in your business. So we do have a video on this channel all about how to do a trademark clearance search on your own without hiring an attorney. So we'll link to that in the show notes or the description of this video. Definitely check it out. And just know that a simple search on Google, social media, and the US Patent and Trademark Office's website, uspto.gov, can help you check for similar trademarks and can help you be proactive when it comes to avoiding some of those sticky situations that I described. So what are the benefits of trademark registration? I mentioned earlier, registering your trademark gives you those rights across the country. Registering your trademark with the US Patent and Trademark Offices does give you exclusive rights to the use of your trademark in connection with your class of goods and services. Every trademark registration is in connection with a certain class or category of products and services, and your job is to identify yours and secure those rights, which is especially important for online business owners that reach a national audience and work with people or sell a product to people who live outside of your city and state. Federal registration can also help prevent consumer confusion and protect your brand's goodwill. It can also give you a legal backing to enforce your trademark rights if somebody tries to use your trademark or tries to use a different trademark that is a little too close to yours. While you can do some initial searches yourself, and I encourage you to, I also highly recommend working with an attorney for the actual registration process. Trademark attorneys can help you by performing a thorough clearance search of their own and providing you with their legal analysis and legal opinion around whether or not you'll actually be able to secure exclusive rights to the use of this and if there is any risk associated with the use of this trademark. And they can also help you navigate the actual registration process. They represent you as your attorney of record, and they will communicate with the U.S. Patent and Trademark Office's examining attorney and their office in general on your behalf. Sometimes this process can take anywhere from 1 to 2 years, possibly even more, depending on the specific circumstances of the situation. So it can be really beneficial to have a trademark attorney in your corner for these situations. Now, once you start using your trademark, even before it's registered, even if you haven't applied for a registration, you can use the small TM symbol. This lets others know that you are claiming rights to this mark. This isn't a generic word or phrase that anybody in your industry can start using. After your trademark is registered, you can then start using that circled R symbol. And remember, the circled C symbol is for copyright, not trademark. We have a video on this channel all about the difference between the TM, the circled R, and the circled C. If you want more information, definitely definitely check that out. Using these symbols correctly puts others on notice of your trademark rights and can act as a proactive measure and preventative measure to help you avoid infringement situations or other people using your intellectual property without your consent. Protecting your trademarks is something you should take really seriously. It's important to conduct regular clearance searches over time to ensure that nobody else is using your trademark. So that means you could consider setting a regular event, maybe once a month, maybe every other month, maybe once a quarter at minimum, to do a search online on social media, on YouTube, on podcast players, on Amazon, on the USPTO website, just to make sure that nobody else is using your trademarks. Protecting your trademarks is important because every time you promote your business and your offerings, you are investing in these valuable IP assets. So you want to make sure that you're the only one showing up when someone searches for your brand and your trademark in particular. I hope this episode clarified what trademarks are and how you can use that to protect your business and brand. Business today is very different than it was 20, 30, certainly 50 years ago, but even 10 years ago. Your assets are most likely in the form of intellectual property. It's unlikely, if you're watching this video, that the bulk of your business value is derived from physical assets, inventory, equipment, etc. It probably lies in your business's intellectual property, including your trademark assets and your copyright assets. Trademarks are essential and can be very valuable assets. So do what you would do in any other instance where you have a valuable asset and take the necessary steps to select, register, and protect them adequately. If you found this information helpful, please give this video a thumbs up and subscribe to our channel for more business and legal tips. If you have any questions or topics that you'd like me to cover on the business of doing business, drop them in the comments of this video or share them with me via the link in the description of this episode. I'd absolutely love to hear from you. Thanks for tuning in, and I will see you in the next episode. Peace.